Supplemental list, item number 8. Pronouncement of judgment. WPC 6081 of 2021.
Government advocate is not there, Mr. Rahul Dhar. Mr. Majumdar, this you must be knowing about this matter. It makes no sense you are there or not. On the basis of the contention so raised, I had framed as many as 3 points for determination. As to whether a government servant who has been put under suspension would be entitled to a direction for reinstatement on the basis of the law laid down in Ajoy Kumar Chaudhary, even though in the meantime the memorandum of charges of the charge sheet has been served upon him. The second point of determination is what is the right of the government servant if the memorandum of charges of the charge sheet is served. Number 3 is whether in the facts of the case the petitioner would be entitled to reinstatement to his service. In paragraph number 38 and paragraph number 43, taking into account the judgment in Ajoy Kumar Chaudhary, I hold that upon completion of the 3 months period, a right accrues upon the authority, upon the delinquent employee. But the said right has to be exercised. Upon exercising the rights by intimating the authority, it is the duty of the authority concerned for the purpose of reinstating him as it is the law and the office memorandum dated 4/2/2020. However, I held that as the basis on which Ajoy Chaudhary was decided by the Supreme Court was on for the purpose of moderation of the suspension orders. Once the order of reinstatement comes, once the memorandum of charge is being served prior to the order of reinstatement, that right extinguishes. The second point of determination, which I had framed as regards what is the right upon the memorandum of charge being submitted. At the time of serving the memorandum of charge, the authority has also to take a decision on that matter as to whether his further suspension is required by way of a reasoned order. These aspects are also there in the office memorandum dated 4/2/2020. However, it is seen that every now and then we see every time the cases are before this court on the basis that Ajoy Chaudhary, principles of Ajoy Chaudhary, the memorandum of charge or the office memorandum dated 4/2/2020 has not been followed. This court therefore directs the Chief Secretary to take note of that aspect of the matter and take action against the erring officials which violates the principles of Ajay Chaudhary as well as the office memorandum dated so and so. Now, the third question which comes out here is to whether the petitioner herein would be entitled to reinstatement. On the ground that the memorandum of charge has already been given to him on 24/11, on the basis of the judgment in the case of Ajay Chaudhary, he is not entitled to. Then this court goes into the question as to what are the various law, what is the law as regards suspension and all. And then calls out that various principles on which the review authority has to take into account. First of such reason is, in the instant case, the charge sheet mentions that there are various persons who are in judicial custody. The rules of 1964 does not permit the inquiry officer to summon a witness, for which the inquiry officer, knowing it very well, have also requested the authority concerned for giving him the appropriate approval for doing so. I've said it, that it is the authority, respondent authority has to take a decision on this matter. Otherwise, if effective steps are not taken by the respondent authority concerned in that regard, thereby enabling the inquiry officer to examine the prosecution witnesses at serial number 3, 4, 5, and 6 of the memorandum, coupled with the right to be given to the petitioner for cross-examination, the culmination of the disciplinary proceedings would be in the realm of uncertainty. Then, taking into account that clauses 2.13 and 2.14 of the manual stipulate that the order of suspension, which has to be normally, not only affects the delinquent employee, but also the state government. As such, this aspect of the matter, which also requires to be taken into account because of the fact that at the time when there is an order of suspension, the delinquent employee continues to hold the lien over the post. This post cannot be filled up permanently. And under such circumstances, the authority concerned has to take an appropriate decision in that regard as to further continue with the suspension order or not. Then, while dealing with Ajay Chaudhary and what has been given in paragraph number 21, whereby a balance was tried to be maintained with the right of the prosecution, with the right of to live with human dignity, there are certain things which have been mentioned, that these persons concerned can be put or transferred to any location, or he may be forbidden from doing various things. These aspects of the matter also has to be taken into account. Another aspect is that in CID PS case number 21/2020 and PS case number Borpeta PS case number 43/2021, the evidence, the investigation is complete, evidence have been already collected. The authority therefore needs to take a decision as to whether in such circumstances there should be a further continuation of the suspension order. However, as could be seen, except in the minutes of the meeting dated 9/12/2021, there is no other minutes wherein it has been, these aspects of the has been taken into consideration. This court had granted one additional opportunity to the respondent authorities to decide on the basis of the parameters laid down and within a period of 15 days by way of a reasoned order. That is why I sought for you. Because Mr. Rahul Dhar is not there and it may not have been communicated, the decision may not be communicated. Now you know. Which one? Yes. No, just for example, in that judgment, which I've also taken note of, in the case of Rafid Ali, a person cannot be, while he is in custody, if the 3 months is over, he cannot be reinstated because 6.2 still keeps on operating. Ajay Chaudhary's judgment cannot be said that the 6.2 has become useless. So it remains. Now you can also have this particular disciplinary authority remaining as a watchdog outside the jail and to know when he is released. So his release would only come from the date he intimates. I've also held that while passing a review order, you can't do it. I've specifically held out here. And you see here, the observations made herein above are relevant and pertinent aspects which ought to have been and is required to be taken into account at the time of reviewing as to whether the further suspension of a delinquent employee is required. Merely because the disciplinary proceedings are pending, the authorities cannot keep the delinquent employee under suspension for an indefinite period, as the same would not only be affecting the right of human dignity of the delinquent, but could also affect the administrative exigencies of the respondent state. The raising of that question, Mr. Dhar, how do you do it? This created the biggest problem. No, it says at the time of submitting the charge sheet also, you have to take pass a reason order as to the necessity for further continuation. It says, and in fact, that office memorandum dated 4.2 was there categorically, but it is not followed. If that is being followed, the matter ends. We don't see a host of litigations out here. The office memorandum further says that if it is not done, senior most secretaries will be put to disciplinary proceedings. But then also nobody cares. Every now and then we get this of a particular year. As regards the first question, see, if you see in Ajay Chaudhary, paragraph number 1 will show that Ajay Chaudhary was suspended on 30/11/2011. And at paragraph number 6, it has been mentioned that on 24/9/2014, he would be served the memorandum of charge. And it is in that perspective at paragraph number 22, the Supreme Court said that as the memorandum of charge has already been served, nothing remains. I hope here also this judgment also benefits others, that while reviewing, you can't review just saying that we are having a departmental proceedings. I've also held one very important aspect, that merely because there is a criminal proceedings, you can't keep a person under suspension. Because that is why the Supreme Court in Promote categorically mentions that even if that person was arrested, this was also an IS officer, IPS officer, he was arrested, there was a criminal proceedings going on, then also the Supreme Court directed him to be reinstated to a non-sensitive post. So this also aspect needs to be taken note of. Before ending the bench, a detailed judgment on suspension had happened. In fact, Rafed Ali, if you see, Ajay Chaudhary was followed. Rakibuddin Ahmed says, the division man says you have to follow that. But how do you follow it? If he is inside, how can you follow? How can you count 90 days? If he is there inside, can you serve him a memorandum of charge? Would it be in terms with 311?
Delhi Schedule number 1 to 3.
So item 1 and 2 I'm referring to. So these methods have become infructuous. 1 and 2. Tenders are of 2021, and when it was for 2 years. I know both have become.
And 3?
3 years.
I'm referring. If information for the client is does not.
What does it heard me? Item 1 and 2. Heard Mr. B. Gugoi, the learned counsel, appearing on behalf of the petitioner. Mr. D. Mujumdar, the learned additional advocate general, assisted by Mr. Ardhor. The learned counsel, appearing on behalf of the petitioner, submits that the
But to our information, the tenders have been already cancelled by the department.
submits that as the tenders, which were the subject matter of the instant litigation, have already been cancelled by the respondent department, nothing survives in the writ petition for which the petitions have become infructuous. Accordingly, both the petition stands closed as it has become infructuous.
Same order, only thing we have consent from the client.
Heard Mr. R. Sharma, the learned counsel, appearing on behalf of the petitioner. Mr. D. Mujumdar, the learned additional advocate general, appears along with Mr. Ardhor, appears on behalf of the respondent departments. It has been submitted by the learned counsel for the petitioner that the petitioner does not want to press the instant writ petition. Accordingly, the writ petition stands closed as withdrawn. Agar order or A2 order, interim orders, if any, stands vacated. A2, in view of the withdrawal, in view of the order passed in the main writ petition, the I stands dismissed.
Item number 4 for admission.
Am I okay? Yes. Heard Miss S. Roy, the learned counsel, appearing on behalf of the petitioner. Mr. B.K. Jain appears on behalf of the respondent. The learned counsel, appearing on behalf of the respondent, seeks an accommodation. What is that order you are challenging?
My amendment application was rejected.
Rejected.
Order is case is 91 million.
What is your amendment application?
Amendment application is at page 75, my lord. I sought an amendment in respect of civil bill and my lord.
Hmm?
In respect to civil bill and of the
According and agree to give.
paragraph 8, I have stated my amendment application.
So you have sought for amendment of Schedule B.
Civil bill.
This could have been allowed. What was the stage?
Stage issue has not been framed.
What? What do you mean? This amendment can be even allowed at the time of arguments. Nothing to submit. The law is settled. Anyways. Mr. B.K. Jain, the learned counsel appearing on behalf of the respondents, seeks for an accommodation. List the matter again on Monday. In time order passed earlier shall continue. Monday. Honey, 11. Eh? 11? 11 Sunday? Oh, 12. Hey, Kali at the matter at 12 to play it.
Hello, 5.
Kali matter to 13 koi riba. Apni listen. Kali matter 13.
Five.
It orders the region. No.
Five order.
None appears on behalf of the applicant on call. None appears on behalf of the petitioner on call. For end of justice, the matter stands adjourned till 12/6/2023. It is made clear if the petitioner is not represented, the instant writ petition shall be dismissed. The instant petition shall be dismissed for non-prosecution.
And number 6.
Yes. Oh, that review.
Yes, Lord.
Condonation.
No.
Condonation. Yes, tell me. The review has been done because you were not present.
I was not present because my brother.
There is nothing else.
No, there are other,
There is nothing else.
there are other points.
You should have gone to the Supreme Court. If there were something, go to the Supreme Court. Why is the review?
No, I may be heard later.
I am hearing you. I remember that matter.
No, Mr. J. Das, who appeared before your lordship, my junior, he was not engaged counsel in that case.
So,
And he had submitted that matter may be taken some other day because I am out of station. Lord.
so
And in such, there are two Supreme Court decisions, right? If the counsel of the is not heard, in that case, matter could be reheard.
matter was not heard means that person was there. If you are saying that, then on next occasion, we are never going to adjourn on when your junior is appearing.
And junior was lordship not the engaged counsel.
Not engaged, but he has the authority under Order 2, Order 3, Rule 2.
Yes,
Then
the authority, lordship
That
only
authority is
put
there when
for
he's
adjournment.
when you are saying that he's your junior.
He-
Mr. Roy, these type of technical thing
lordship
doesn't
only
apply
2 months
good to
back,
this
he had
court.
joined my chamber,
So
Mr. J. Das. And
when he appears out there on behalf of the appellant, he has to
but
be.
he was not the choice of the client, Lord.
No, he was not the choice of the client cannot be a ground of review.
Lordship, I am submitting two judgments of the apex court. Thereafter, your Lordship, please pass the order.
And why there was a delay? Why there is a delay of 75 days?
I have explained, Lordship.
What is it?
Delay is, Lordship. Para 4-5, Lordship.
Huh?
Para 456 of the condition.
Who has filed this? I'm the petitioner. What about the petitioner, other petitioners? A, B, C, D?
They are the heirs of the original application.
Understood. F is also there. Then why the others could not file?
No, here the petitioners are Lordship up to.
No. Why the others could not file this application?
All the legal heirs are the parties. They are all the legal heirs of late Govindo Das, they are the parties who are also the parties to the RSA.
Understood. But why the others could not file? The illness is only of the applicant number
Because he was
1F.
taking the steps on behalf of others.
Then why not the others? There's no explanation as regards the others. Not a single word it is there.
Lordship, I have stated in page 4.
I've seen it.
Para 5, Lord.
I have seen it. Then
He was taking a step.
you file your objection. You file your objection. Mr. D. Chaudhary, the learned counsel appearing on behalf of the respondents, 4 weeks time for filing objections. Accordingly, let the matter be listed after 4 weeks.
Public.
An innocent party suffering injustice on account of default of the lawyer.
I defaulted.
So why not some penalty be imposed upon you? Not upon you, upon that Mr. J. Das who represented. Why should his name should not be sent for the? Why shouldn't I send the name, his name to the department?
Junior who appeared.
No, I am just giving you this notice. On the next date, why you think about the answer? Why either not your name, you were not there. Why not the name of Mr. J. Das, who did not have the authority, appeared before this court and appeared before this court? Why his name should not be sent to the Bar Council for disciplinary proceedings?
As your Lordship has pointed
No,
out,
Mr.
provider clearly provide.
Then why you are making that submission?
Because he
Mr.
was
Roy,
he was not
whatever
the
may
choice.
be, I may be sitting out there in the pension bench, but I have not forgotten each of the rules of order, the CPC. I remember what it is. Next.
Number 7.
But you answer that on the next occasion. Yes, Mr. Gogoi, what about this thing? Heard Mr. MP Sharma, the learned counsel appearing on behalf of the petitioner. Mr. B. Gogoi appears for the Finance and Taxation Department of the Government of Assam. The learned standing counsel for the Finance and Taxation Department of the Government of Assam had submitted that the effect of the amendment was duly applied to the finance effect of the amendment to rule. Rule 9, Rule 9(6) Roman 2, isn't it?
Yes, sir. It's
Rule 6.
Not 2. I think rule 9. Six is there, na? Good. Some services manual. Where is that ministerial rules? Rule 6. Amidst that rule 6 6B of the Assam Ministerial District Establishment Service Rules 1967. Was duly applicable. Then the amendment to the rules was duly applicable to the Finance and Establishment Department. And there was no requirement for passing a fresh administrative order in that regard. The said submission be brought on record by way of an affidavit. 4 weeks' time is granted for filing that affidavit.